It could not give her back her left foot. I want you to hold on to that for the next few minutes, because everything I'm about to tell you, every page I read, every word I heard, every sentence I spoke from that bench, points back to that one thing, and none of it brings it back. When I finished speaking that afternoon, the courtroom went so still that I could hear the vent above the clerk's desk click twice. A deputy near the rear wall shifted his weight, and the leather on his belt made a small sound that carried farther than it should have. That was silence 3. I want to tell you how I arrived there. I have held this story for a long time, not because I was afraid to tell it, because I wanted to tell it right. Subscribe and turn on notifications. That is the only reason I am here today, to tell it right to the right people. Subscribe before I keep going. The woman at the center of this case was Teresa Boone. She was 51 when she first entered my courtroom on June 17, 2025. And what I noticed first was the care she took when she turned to sit down. Not slowness for effect. Care learned the hard way. During the second day of trial, while a pharmacist was testifying, she straightened a stack of receipts by date and smoothed each one flat with the side of her hand. I have not forgotten that. People who have spent months being doubted often begin by arranging the proof. The defendant was Evan Kessler, 42. A regional sales representative for Halcyon Therapeutics. He was polished in the practiced way some men are polished when they want authority to look like calm. He watched the jury when it helped him, his lawyer when he needed direction, and the tabletop when testimony turned against him. One thing about him was plainly human. On the morning he testified, he opened his briefcase, looked at a child's drawing folded into quarters, touched it once and put it away. That made the whole thing worse for me, not better. It told me he knew what it means for one person's choices to follow them home. The incident happened on Friday, March 8, 2024 at 2:16 p.m. inside Maple Ridge Endocrinology at 640 West Mercer Street in Dayton, Ohio. Teresa Boone had gone there after Benton Family Pharmacy told her insulin pen refill would cost $421.63 that month. Evan Kessler was in the clinic for what the calendar called a product update lunch. While he stood near the nurse's station, Teresa asked whether there was anything cheaper that would still work the same. He said, "There isn't a lower-cost version I'd put a patient on." That sentence came in through testimony from Teresa and nurse practitioner Dana Liu, and through a note Dana wrote the same afternoon. Teresa then asked, "So what do people do if they can't pay that?" Evan Kessler said, "They wait for the card cycle, or they go without the convenience." I did not need anyone to tell me how to hear that. The words were plain enough. What he did not say was this: Halcyon had an authorized generic vial with the same active insulin that could be dispensed for $68.40 cash at participating pharmacies. He also did not say the company had a 30-day bridge program for patients caught between refills and coverage. 3 days earlier, on March 5, 2024, he had received an internal district memo titled Lower Cost Pathway Talking Points. The next morning at 9:07 a.m., he emailed the clinic manager and said, "Please remove outdated savings sheets from patient areas until brand messaging is consistent. Those sheets name the cheaper option. Subscribe. Not for me. For the reason I'm telling this, some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. Cases like this do not arrive all at once. First came the indictment on September 12, 2024. Consumer fraud, tampering with records, reckless endangerment. Then came the binders. Clinic emails, pharmacy logs, insurance records, bonus sheets, training slides. The paper looked ordinary. That is one of the colder facts of work like this. Harm often travels in documents that do not look like harm. One page in the pretrial packet made me stop. It was a sentencing exposure chart, and next to Teresa Boone's name, it listed economic loss first and medical consequence second. That ordering was standard. It was also, in that moment, a clean picture of the gap between what law can sort and what a body has already paid. If you were sitting across from me at a kitchen table, I would explain one legal point this way. Business records often come in because routine paperwork can tell the truth without drama. People think that sounds technical. Sometimes it is simply the law's way of admitting that office paper can wound people too. By the time trial began, I knew the outline. I knew what the state said happened, what the defense denied, and which facts still had room around them. What I did not know yet was where the room itself would go quiet. There were 3 moments in that courtroom where the silence was not empty. It was full of the thing that had just entered the room and could not be taken back out. Those 3 silences carried the whole case. From the bench, I watched entrances closely. Teresa came through the side door with her daughter, Lena Boone, half a step behind her. From where I sat, I could see something few others could. Before she reached counsel table, Teresa glanced once toward the witness stand, then down at her prosthetic foot and tugged the cuff of her pant leg lower over it. One quick motion, not shame, not display, preparation. Evan Kessler entered with counsel and a banker's box. He looked first at the wall clock, not Teresa, not the gallery, not me. His left thumb kept rubbing the edge of the box lid. Small things become loud from a bench if you sit there long enough. Silence. 1 came on the afternoon of the first trial day. Teresa had already answered the basic questions. Then her lawyer asked what she said in the clinic after being told the price. Teresa looked once at the exhibit screen, then back to counsel and said, "I asked if there was anything I could still afford." After that, the room went quiet for 4 seconds. I know because I looked down at the timer without meaning to. The court reporter broke it first by resetting her hands. That silence changed the shape of the case for me, not the facts, the shape. Until then, the file was full of product language, messaging guidance, and coverage pathways. After Teresa said that sentence, I understood the center of the case more plainly. She was not asking for a favor. She was asking for the truth at the one moment when the truth could still help her. The first wave of evidence followed. A laminated patient handout was found in the bottom drawer of a desk in exam room 3. Someone had drawn a black line through the section listing the lower cost vial and the bridge program number. The marker used on the sheet matched one found in the Halcyon sample bag Evan Kessler carried that week. Then came his quarterly bonus record. It offered an extra $1,800 if branded pen uptake in his territory stayed above 82% through March 31st. On March 8th, it sat at 79.4%. Then came the hospital records. Teresa had stretched her insulin by taking partial doses for 18 days. On March 27, 2024, at 11:42 p.m., she was admitted to Miami Valley Hospital in diabetic ketoacidosis with an infected wound on her left foot, made worse by uncontrolled blood sugar. On April 9th, surgeons amputated at the ankle. I could name the violation. I could not return what the violation took. The defense cross-examined where you would expect them to. They pointed to clinic responsibility, insurance confusion, pharmacy counseling, missed follow-up calls. They argued that a sales representative is not a prescriber and not the final gatekeeper. Part of that was true. Systems fail in layers, but the law does not stop caring because more than one person could have done better. It asks whether the person charged knowingly placed concealment where honesty belonged. If something in what I have said so far has stayed in your chest, subscribe, because what I am about to tell you next will stay longer. Subscribe now and then let me keep going. There is a memory from my own life that kept returning while I heard this case. I was 10 years old in our apartment kitchen. My mother had 3 pill bottles open on the table and an electric bill folded in half beside them. She used a butter knife to split one tablet, then lined the halves on a saucer in a straight row. The refrigerator hummed. Nobody gave a speech. She was only trying to make the month longer than it was. I did not bring that memory into court. It came with me anyway. When Evan Kessler took the stand on the 4th day, his voice was softer than it had been in any recorded call the jury heard. He said, "I was following field guidance." That was one defense theme. He said the lower cost rollout had been uneven and that he believed the clinic was waiting on updated training. Then he said patients don't need a menu, they need the best option. That was the entitled sentence. It sounded clean. It also told me he had grown used to deciding what another person should not know. He was asked whether he understood that some patients skipped doses because of cost. He said, "I knew people struggled." Yes. Quiet. Still wrong. He was asked what he did with that knowledge. He said, "I assumed the clinic would have that conversation if it mattered." I wrote that down. I looked at it for a long time before I moved on to the next page, because in that sentence he placed the consequence just outside his own duty and seemed to believe that helped him. It did not. Silence. Two came at the end of his testimony. Not after a confession. There was none. It came after his lawyer asked one last question about intent, and Evan Kessler said, "I never wanted Ms. Boone hurt. I just needed the quarter to close before we changed the message." That was the sympathetic sentence, and it revealed more than he meant to reveal. Then the room went quiet for 6 full seconds. Silence. One had been the silence of recognition. Silence, too, was different. It was the silence of arrangement. The facts had settled into their final order. Around that silence came the evidence that ended the last of my uncertainty. A district manager testified no one had instructed reps to suppress the lower-cost pathway. A pharmacy technician from Benton Family Pharmacy said, "We had the cheaper flyer in the bottom drawer." I wrote that down, too. Not because it was dramatic, because it was small and final. There it was, not gone, not unavailable in the drawer, and not given. I will say this once, plainly. I could sentence him, I could not undo him. Subscribe before I go further. I have more to tell, and the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. I listened carefully to the defense closing because fairness requires listening even when your mind is narrowing toward a conclusion. They said Teresa's injury came from many failures, not one. They said the state was trying to turn carelessness into crime because the outcome was severe. They said Evan Kessler was a salesman inside a system that trained bad habits until they felt normal. One part of that gave me real pause. People inside systems do absorb wrong instructions until those instructions feel routine. I have seen that before, but the pause ended where choice became repeated and personal. He deleted the lower cost line from a handout. He told clinic staff to pull the sheets. He stood within hearing distance of a woman asking what she could still afford and answered with concealment. He tied it, in his own words, to the quarter closing. By the time I sat to write my verdict, law and fact were facing the same direction. I found Evan Kessler guilty of consumer fraud, tampering with records, and reckless endangerment. I found him not guilty on one count of wire fraud because the proof on that count did not reach where the state wanted it to reach. Precision matters. The law is not served by taking more than proof gives you. It is served by taking exactly that much and not less. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. Before I spoke the sentence, I looked over the room and saw what rooms like that always hold in the second before permanence. Teresa had both hands folded over the handle of her cane. Lena Boone's jaw was tight enough that I could see the muscle move from the bench. Evan Kessler stood straight, but his breathing had climbed high into his chest. The air in the room felt thin in the physical way air sometimes does when nobody is willing to move first. I said, "Mr. Kessler, I am ordering you to pay a criminal fine of $250,000 to the Ohio Patient Access and Insulin Relief Fund." Then I told him why. Money was the language he had chosen to understand. Bonuses, market share, quarter-end pressure, branded uptake. Part of the sentence had to move directly against that same language and send it toward the people cost had already cornered. I said, "I am also ordering that you be prohibited from working in pharmaceutical sales, pharmaceutical marketing, or any patient-facing drug promotion role for 7 years, and that any state registration required for those activities is suspended for the same period." I told him this was not about stripping a title for display. It was about preventing him from standing in another clinic with the power to shape what a patient hears when the truth matters most. Then I said, "As a condition of probation, you will complete 1,000 hours of supervised service with the Dayton Medication Access Network, specifically in intake, price disclosure packet assembly, and patient assistance form processing." I did not send him to generic service meant only to fill a clock. I sent him to the precise place where the truth he concealed now had to be handled with his own hands. And there was one more thing. I said, "You will prepare and deliver a public statement in writing and aloud at the annual Ohio Association of Community Health Clinics conference, at a staff meeting at Maple Ridge Endocrinology, and at a patient town hall organized by the Dayton Free Pharmacy Coalition." I required the statement to name the lower cost pathway, the pressure that distorted what patients were told, and his own conduct in plain terms. Apology without accuracy is only another form of hiding. Then I said, "You will also pay for Ms. Boone's next 2 prosthetic fittings, 12 months of transportation to and from physical therapy, and 12 months of diabetes supplies not covered by her insurer, including glucose sensors and emergency insulin backup." I did not call that mercy. I called it the smallest restorative order tied to the exact needs his conduct helped create. A lost foot is not restored by fittings, but a woman should not keep receiving fresh bills from an old wrong. After that, I spoke to him directly. I said, "You did not invent greed, and you did not invent pressure inside drug sales. What you did was smaller than that and more personal. You stood near a patient who asked what she could still afford, and you chose to hide the answer." I said, "To your family, I will say only this. You did not commit this act, and you do not deserve to be used as a shield for it." Then I said, "Your position required candor, where cost and survival met. You chose messaging instead." The last line was not about him, it was, "This case begins and ends with Teresa Boone." Subscribe if you are willing to carry this story past this video. That is what subscribing means to me, not a number, a person who will remember this. Subscribe. Then Silence 3 arrived in full. My hands were flat on the bench. Nobody spoke for almost 5 seconds. Silence 1 had opened the human center of the case. Silence 2 had closed the factual distance. Silence 3 was the silence that comes when the law has finally caught up as far as it can, and everyone in the room knows that as far as it can is not the same as far enough. I heard a pen roll once across counsel table and stop against a legal pad. The first person I watched when movement returned was Lena Boone. She did not look at Evan Kessler. She went straight to her mother, knelt beside her chair, fixed the hem of Teresa's pant leg where it had caught above the prosthetic strap, and said very quietly, "You don't have to keep proving it now." I was close enough to hear that from the bench. A little later, Teresa turned to her daughter and said, "I only needed the truth in time." I have said that sentence back to myself more than once since this case closed. I remained seated while the courtroom emptied. Judges often do. You let the room clear around the ruling before you step back into chambers. Evan Kessler stood still while his lawyer gathered papers into neat stacks that no longer mattered in the same way. When I finally rose, there were only a few people left, and the room looked almost untouched except for the water glasses, half full, catching the overhead lights. There are other people I want to speak for. Other cases where someone needed a voice in that room, and what they received instead was procedure. Subscribe, and I will tell you those stories when I am ready to tell them. This was the first one I was ready for. The appeal was filed on August 4th, 2025. It went to the 2nd District Court of Appeals of Ohio. On September 18, 2025, that court affirmed the convictions and every material part of the sentence, sending back only a narrow issue so the public statement locations could be stated with more precision in the written order. In plain language, the appellate court said the evidence showed he knowingly hid a lower-cost option and that the sentence matched the conduct. The whole process took a little over 13 months from sentencing to final mandate. I expected the appeal. I still read the ruling twice. Later, I learned one specific thing. On November 6, 2025, at a church basement medication clinic on South Grant Avenue in Dayton, Evan Kessler completed his first public service shift. A probation report said that at 3:22 p.m., an older man in a brown work jacket asked, "Is this the cheapest one or just the one they hand out first?" The report said Evan Kessler turned the chart toward him and read every price line from top to bottom before answering. That is what I learned. I leave it there. What this case left me with was not only judgment, it left me with a question I still have not put down. At what point does a person begin to treat someone else's need for medicine as a piece of market behavior instead of what it is? I have thought about that for a long time, and I still do not know the full answer. I know only that the change, when it comes, must be smaller and quieter than people expect. A line removed from a handout, a number not said aloud, a patient told there is no other way when there is. If you have ever sat in a chair and tried to ask for help without sounding like a burden, then you know the look I saw on Teresa Boone's face before she testified. It is the look of someone trying to make her own needs smaller so maybe another person will not turn away from it. It is the look of someone already preparing to be told no and deciding to ask carefully anyway. If that feeling lives anywhere in you, then hear me clearly. When you ask what you can still afford, you are not asking too much. And if you work where cost, access, authorizations, denial codes, coverage sheets, or product language pass through your hands, then here is the question I wanted to ask from the bench but could not because it was not a legal question. When did the person in front of you become less real than the number you were protecting? Here is the one specific thing I will offer. Put the cheaper option on top of the stack. Say the lower number out loud first. Do not wait to be asked 3 times. It could not give her back her left foot, the ordinary act of standing up and stepping forward without having to think first. The life before that question about cost was answered with concealment. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. And if you say anything in the comments, say it as if someone carrying their own version of this might be standing there reading beside you.